You don't apply the strict rules of technicalities.
Even then, my lord,
Now, what prejudice do you suffer?
I suffer, my lord, because my lord, I am the party who will have to pay the claim, my lord. That is the difficulty. And I was not allowed any opportunity to place my objection. I filed a petition, my lord, on the next day.
That's a different matter.
Yes, that petition, my lord, was summarily rejected.
Your vehicle was not insured.
Vehicle was not. That is why, my lord, the prejudice part comes in. And, my lord, on 16th May 2024, Lordship will find at page 34, I filed this petition that I have not been heard at all. The petition was filed summarily without any ground, nothing, no documents. My lord,
Suppose we remand back, give you a hearing, and again the same order is passed, then?
My lord, the trial
See, the apprehension which you are now expressing, that evidence has not been properly adduced, even in the chief. There are documents which are not originals.
I am not in that part.
You take the advantage.
I am on the part of jurisdiction, whether the tribunal had the jurisdiction to recall its own order in the absence of the conditions precedent. There are coordinate bench judgments of this court under Order 17. Order 17 will apply because whether it is MSCT, it's a civil procedure guided by the CPC. There is no separate procedure as such under the principles of civil law will apply. Well, Order 17, my lords, once the...
In the tribunal, the CPC will apply.
CPC will apply.
The strict rules of CPC will apply in a tribunal.
No, strict rules of evidence may not apply, my lord, but all the rules of CPC may not be applicable. But for first, my lord, the rules relating to appearance, witness, adjournment, they have to be applied.
We may not agree with
otherwise,
let us see what is that.
Yeah.
There are decisions only for particular action.
Look.
You take the powers, you can act as a civil court.
Yes.
For calling of witnesses,
Yes.
for summons, for discovery, all those.
Yes.
Nothing beyond that. Otherwise, it's...
Because otherwise, my lord, there is as such no bar also in application of the CPC.
Which one are you?
My lord, I am first on, my lord, coordinate bench.
Patna High Court.
Yes.
Diputas.
Yes.
Yes.
Diputas, my lord. If your lordship will have, my lord, the second page.
Yes.
This application was under Article 227 of the Constitution challenging the order dated so and so, whereby the evidence of the defendant which was closed, but an order dated so and so was sought to be recalled by the petitioner by way of an application under Section 151 CPC was rejected. I have heard so and so. From the impugned order, it reflects that the defendant had failed to file his evidence on affidavit on 6 consecutive dates, and thereupon on 10/10/2013, the court below had closed the evidence of the defendant and fixed it for arguments. Thereupon, the petitioner filed an application after a period of 4 months on 18/2/2014 for recalling the said order dated 10/10/2013. The court below, taking into consideration the provisions of Order 17, Rule 1, and more particularly to the proviso that no adjournment shall be granted for more than 3 times to a party during the hearing of a suit, have rejected the said application filed for recalling of the order. At this stage, it may be relevant here to mention that when an application is filed under Section 151 CPC for recalling of an order, same is permissible when the said order is sought to be recalled, has been obtained by fraud practiced upon the party, when the court is misled by a party, when the court itself commits a mistake which prejudices the party, or a judgment was rendered in ignorance of the fact that the necessary party had not been served at all or had died as the estate was not represented. The above proposition of law is well settled by the Supreme Court in the case of Budhia Swain, which also I have to. Now, in the instant case, none of the above...
This was a matter of the MSCT.
No, this was not MSCT.
Then...
Regardless of that, Lordship will conceive a situation.
This application is not filed under 151.
There is no provision, under which it has been filed. That is the part.
Why is it required that you're bound to mention a provision in a tribunal?
Then the tribunal would have to have some inherent power. That inherent power has to come from 151 CPC on. There is no other provision. The tribunal, the Motor Vehicles Act does not have prescribe any inherent power to recall. Let us conceive a situation, where at any stage of the case, they can file a recall application.
It is not any stage. It's a claim of which year? It's not a case where indefinite adjournments have been taken. The process of law has been taken for a ride. No, some 3 adjournments, they have filed the evidence. It's a motor accident claim. The objective is benevolent.
Once their right was closed, they had the remedy before this court. They could have come, but they should not have gone there and
The tribunal has given them the relief. Why should they come before this court?
The tribunal has
Sorry,
wrongly given
Heard
that.
Sri A. Ganguly, learned counsel for the petitioner who has filed this petition under Article 227 of the Constitution of India.
It may remand it back, Malad, for at least hearing me. I have not even been heard by the tribunal, Malad. But this is a default situation, Malad. My objection, if I am not prejudiced, then, Malad, I have to even some sort of a reply, Malad. My objection was filed on the very next day. I was not given any notice.
You are now shifting your arguments.
No, Malad, in any, I
You
have
have
to be
said
heard,
that
Malad.
powers.
No, Malad, I'm not saying. There is a jurisdictional issue here. I have to be heard by the learned trial court.
That is not a jurisdiction, it's a procedural aspect.
No, the learned
Where is the jurisdictional issue?
Exceeded its jurisdiction, Malad. The power under 151 cannot be
That's a
exercised.
procedural aspect, whether you give your hearing or in a matter of this kind, where a claim has been raised on the basis because of an accident in an MACT.
Merits, Logic will only examine one aspect. The jurisdiction, the petition has to be under 151. I have not been heard. The order has been set aside.
So, okay.
That part, at least
Revisional powers with 227 powers.
Yes, 227 power. Where is the jurisdiction of the trial court? That is what Dipu Das judgment is saying.
Dipu Das is on a civil process. That the strict rules of CPC are applicable in a tribunal.
Principles
will agree with you.
The tribunal does not have any inherent power apart from one.
It's not a question of inherent power. It's a question of exercising of powers to secure the ends of justice. Nothing else.
The minimum that
you don't leave a claimant high and dry like this. He was not able to produce himself for cross-examination for 3 days. He has shown good reasons, allowed on cost. What else do you need?
No good reason is cited in the petition. The petition is silent.
Oh, who has filed this application under Article 227 of the Constitution of India against orders dated 9/4/2024 and 16/5/2024 passed by, and that to a death case.
Yes. Not here, we are not on merit.
We are on merits. You cannot preclude somebody from even having the matter entertained on merits in a death case. Your vehicle is not insured, that's your headache. You cannot take the recourse of finities or technicalities of law, come to the High Court and frustrate somebody.
The right of hearing has been denied to me. That is my main remark.
We are not on those niceties.
So that's my take.
In MSc, the case number 92 of 2002, within bracket D, before the learned MACT, Sonitpur at Tejpur. Full stop, para. The projected case in this petition is that in view of the projected case in the petition is that the respondents, please have your seat, Mr. Ganguly, had instituted the aforesaid claim before the tribunal, claiming compensation on the deaths of one Nur Islam, alias Nur Islam, in a motor vehicles accident, full stop, in which the petitioners are made the opposite parties, full stop. The petitioners are the owner and driver of the vehicle in question, full stop. It is projected that the petitioners had filed a joint written statement, and on 22/8/2023, the claimants had filed the evidence, full stop. Thereafter, the matter had come up for consideration before the tribunal on 26/9/2023 and 31/10/2023, when adjournment was sought for by the claimants, full stop. When the matter had come up for consideration thereafter, on 5/1/2024, a last opportunity was granted to the claimants, fixing the next date as 26/2/2024. Full stop. On the next date, on the said date, i.e. 26/2/2024, the where is that order? 29.
So
The
26 to
at page 29, I think.
20.
The claimant witness was closed and the next date was fixed on 23/2024. Full stop. Para. On 23/2024, the petitioners had filed an application seeking adjournment for filing of DWs. And on the said date, the opposite party, the respondents' claimants had filed Hazira. Full stop. However, on 9/4/2024, an application was filed by the respondent claimants, which appears to be an application for recall of the earlier direction of the tribunal and to allow the cross-examination of the claimant witness. Full stop. Why the impugned order dated 9/4/2024, the said petition was allowed with cost of rupees 10,000 payable to the DLSA Sonitpur. Full stop. On the said date, it appears that the petition filed by the present petitioners for adjournment for DW was also allowed. Full stop. The tribunal had fixed the next date as 16/5/2024 for cross-examination. Full stop. Para. Sri Ganguly, the learned counsel for the petitioners, has submitted that the aforesaid order, that the impugned order suffers from jurisdictional error, inasmuch as the same was passed without there being any inherent powers of the tribunal to
Section 169 of the MP Act, my submission. 160.
To recall any such order, MV, Motor Vehicle Act. Full stop. It is submitted that the petition has to be construed to be a petition under Section 151 of the CPC, and such powers cannot be exercised by taking recourse to the aforesaid provision of law. Full stop. The learned counsel has also referred to Section 169 of the Motor Vehicles Act, which lays down the procedure and powers of the claims tribunal. Full stop. Para. It is further submitted that the impugned order was passed without giving any opportunity to the petitioners to file any objection. Full stop. It is submitted that while the order dated 26/2/2024, a substantive right had accrued upon the petitioners who were contesting the claim, and that right could not have been taken away without giving any opportunity. Full stop. Para. The learned counsel, in support of his submission, has relied upon an order dated 3/12/2021, passed by this court in CRP 157 of 2014, Dipudas versus so-and-so, which, full stop, this court, in the aforesaid order, had also relied upon the judgment of the Honorable Supreme Court reported in 1999 to SCR.
Lordship, please otherwise 1999 4 SCC 396.
We have SCC. 1999?
SCR.
No, we have SCC submission. You have SCC citation 1999
No,
to SCR, I think.
but it is Beijing in SCR. 1999 to SCR.
Yes, 1189.
Yes, 11.
1999 to SCR. আমি পাইলে to SCC report 1189. Full stop. Para. So Ganguly, the learned counsel, accordingly submits that the interference is to be made by this court against the impugned order. Full stop. Para. The order impugned in this proceeding filed under Article 227 of the Constitution of India is passed by a tribunal, by a motor accident tribunal in a death case. Full stop. The claim was instituted in the year 2022, and it appears that the claimants have already filed the evidence on affidavit. Full stop. Though it appears that 3 numbers of adjournments were sought for production of the CWs for their cross-examination, whereafter the order dated 26/2/2024 was passed, closing the CWs, the respondent claimants had filed an application on 9/4/2024 for which is effectively for recall of the earlier order and for acceptance of the claimant's evidence. Full stop. Para. The learned tribunal, by the impugned order dated 9/4/2024, had allowed the said petition on cost, and there is a specific direction while fixing the next date that it would be only for cross-examination. Full stop. The aforesaid order had also allowed the petition of the present petitioners for adjournment for filing of the DWs. Full stop. Para. The tribunal, exercising powers under the Motor Vehicles Act 1988 and the rules framed thereunder, is not bound by the strict rules of the Code of Civil Procedure. Full stop. The reference to Section 169 of the Act would itself make it clear that it is only for certain purposes that the tribunal would be deemed to be a civil court, and those purposes have been specifically mentioned to be section 195 have been specifically mentioned in section 169 within bracket 2 of the Act. Full stop. The reliance upon the order of this court in Dipuda Supra and also of the Honorable Supreme Court in Budhia Swine Supra are orders which were passed qua the exercise of powers by a civil court in under section 151 of the CPC. Full stop. Para. Though the order dated 9/4/2024 appears to have been passed on the same date when the application was made by the respondent claimants, and apparently the present petitioners were not given an effective opportunity, this court is of the considered opinion that the powers exercised by the tribunal was only to secure the ends of justice, as the entire objective of the motor accident of the codification of the Motor Accidents Act 1988 and the rules is a beneficial legislation whereby the tortious liability of that nature has been codified in a structured in a manner whereby such claims can be easily disposed of. Full stop. Para. The powers to be exercised by this court under Article 227 is a power of superintendence, wherein this court is only to look out whether the orders passed by the subordinate court tribunal was within the ambit of law. Full stop. In the considered opinion of this court, the impugned order does not appear to be one which calls for any interference by this court. Petition accordingly stands dismissed. Okay, next.
Item 45 subpoenas.
Awesome. Yes, Mr. Rajan.
May it please the Lord. My Lord, in a suit for division of share and partition, I filed an application praying for my implement as a successor interest and co-sharer.
This is item number?
Item number 45.
Petitioner is the
Petitioner is the son of
plaintiff. You are the plaintiff.
No, my Lord. I am the son of the proper defendant number 27.
Number 27.
Lordship. Suit, my Lord.
Suit for?
Suit for, my Lord, division of share and for partition of the properties.
Okay, suit for partition.
Partition. My Lord, suit proceeded ex parte for against defendant number 5 to 38. And defendant number 1 to 4 filed a written statement. And defendant number 39 to 43 also filed written statement.
39 to
43. They are all perform. Main
Yes.
defendants 1 to 4. My mother was made proper defendant number 27. My Lord, in the suit, the address, the name of my mother and the address was very incorrectly given. Therefore, notice was shown to have been served to my mother's brother, who in fact the process server report is there, my Lord, who says the notice is served on the brother of my mother, brother of the defendant number 27. Brother is defendant number 28. And from the plaint itself, it will show that defendant number 28 is not my brother. Process server report says served on his own brother, and the plaint itself will show that they say fathers are different, is not my own brother. Therefore, my mother did not
This person who had received notice on behalf of your mother, is the defendant number 28.
28. He is also, against him also, suit proceeded expert.
Okay.
And two others. Defendant number, he received on behalf of defendant number 20, 25, 26, and 27. Two others. The report says that I was not present in the place.
Your mother was not present.
A mother was not present. It is specifically stated. Now, my lord, my mother died in 2018. Then I, my lord, filed an application praying for getting me implemented in the suit.
Substituted.
In fact, I filed showing a wrong provision of law. The trial court said I ought to have filed an application under Order on Rule 10(2), but I filed it on Order 1 Rule 8A and Order 9 Rule 7 because the suit proceeded ex parte against my mother. So I wanted that order, ex parte order to satisfy, recall, and then get me implemented in the suit. That was the idea, perhaps, of the petitioner. But then
You did not file for substitution.
I have not filed because
You filed for inclusion of your name.
I did not file.
But
Perhaps
your rights are accrued only on the death of your mother.
on the death, right? Well,
So
in fact,
you'd be substituted.
I could have,
Yes.
but perhaps, my lord, because the suit against my mother went ex parte. I would step into shoes of my mother. Well, I cannot file my own defense here. Therefore, my lord, I filed an application praying for recalling of that ex parte order, where the notice was not served. The trial court, my lord, quite mechanically,
You filed two applications.
one application
Under
under Order 1 Rule 8A, that was the wrong provision of law.
8A.
I can admit, my lord.
Okay. And the other one, rule?
Other Order 9 Rule 7.
Red width? Red width.
Read with 151.
No, you had filed one application.
One application,
Order 1 Rule 8A.
Order 1 Rule 8A, read with Order 9 Rule 7, and read with 151.
That is red width.
Read with Order 9 Rule 7,
Rule 7.
and read with 151. My lord, apparently, my lord, provisions were not, but Supreme Court, my lord, in a partition suit, the lordship is aware that everybody, my lord,
But 9-7, how will it lie by you? You are a stranger to the proceeding.
It ought to be, because my mother didn't know. My mother.
No, you have a procedure which you know
My lord,
what to adopt.
Lordship.
How do you come into the picture, enter into the room, then
Quite
you make
right.
your submission?
Quite right.
You are not even given an entrance to the room. How can you make a submission?
That's right, my lord. In fact, that's why, my lord, I ought to have filed an application under Order 1 Rule 8, Order 1 Rule 10, for getting me.
That is also one of the procedure which you could have
But the
adopted.
Supreme Court says, my lord, even Order 1 Rule 10(2) is not applicable, is not right. In any case, Supreme Court has statement. But this lordship is aware, relying on Shagram Singh, the Supreme Court in a later decision in a partition suit said the court should not go so technical. Maybe a wrong provision is so, roads should not go so technical.
No, we are not on the provision of law which you are citing while
Lordship.
making an application. But at the same time, you cannot forego. What is the objective
Order
of
to-
having so many orders and so many rules?
No, lordship is absolutely right. I ought to, Order 22 Rule 4 is there, my lord.
We are not on the wrong quoting or not quoting. But what is the substantive relief you are seeking by the application?
Is implemented.
Is implement.
Simply. So the court, even the court can, my lord,
Okay, then what had happened?
my lord, the trial court, the lordship has held, firstly, that I ought to have filed Order 1 Rule 10,
Okay,
that's
okay.
one. Secondly,
Order dated.
my lord,
Order dated.
trial court's order dated 10/5/2020,
10-5,
2020,
24. Page.
page 76.
Okay, what happened?
Now, my lord, trial court has held that the process server's report shows the notice is shown to have been served to the brother of my mother. Therefore, that it is a presumption that I have received the right note. That's not wrong, because Lordship will kindly have a look at page. Lordship will kindly have a look.
This observation, Mr. Rajudri, this observation is on your petition
Yes. In my petition.
and it is rejected or what?
Reject. That's that against that I have come for. I wanted impleadment because I am a co-sharer. And it is an admitted position, my lord, in the plain that my predecessor
Are you precluded from filing a substitution application?
my lord,
Are you precluded from filing a substitution application?
no, my lord, I could have filed.
You want a right to be
My mother
represented.
died
You want a
long
right
back.
to be heard. You get yourself impleaded by
My lord
way of
is right.
substitution.
My lord, because what plaintiff did, he, my lord, got the student.
You have got other siblings.
My lord,
Have you got other siblings?
no, I'm the only son. I'm the only son
Of the mother
of the mother.
of 27.
27. Now, my lord, I cannot take because the suit is in my name because there is already a document, my lord. But in the plain, the plaintiff said that my predecessor entered sold the
now-
land to. Therefore, my lord, I had to file.
No, Mr. Roy, there is one more thing.
Lordship.
Suppose one of the defendant may be ex parte. The defendant has passed away in the meantime. The duty is cast upon whom?
Plaintiff.
Plaintiff.
He did not do that.
Exact. That is the.
That's the
It is the duty of the plaintiff.
plaintiff.
to-
Though it is expert, because
No.
I'm still a part.
That is it. If it is the duty of the plaintiff which has fallen from you,
Lordship.
we are expecting that
Lord.
the plaintiff has not discharged his duties to file application for substitution.
Therefore, my lord,
You need not come in. That I will not. You need not come in on your own. That implead me as a party. So I am the legal heir of a party who was the defendant, passed away. It's the duty of the plaintiff, unless he impleads you,
absolutely. I have taken.
then he will suffer the prejudice.
I have taken.
You
the plea.
have got nothing to lose.
Now, my lord, I wanted to get myself impleaded because the plaintiff has stated a wrong thing. He obtained a wrong decree because he said that my predecessor stole the properties in Dag
No,
Maida.
no, Mr. Roy, those are on the merits of the case.
That's it.
We are not on the merits.
Therefore, my lord,
Let us assume everything what you have said to be correct. The acceptance of the notice by defendant number 28 stating himself to be the brother is not correct. He is not the brother. In fact, the person who had received notice, he is also a defendant in the suit.
yeah, he expected.
Defendant in the suit also passed away.
Yeah.
Your mother, defendant number 27, has passed away.
Hmm.
On your own, you tried to get yourself impleaded. You gave a wrong provision. That's a different matter. Matter rejected. Now, can the suit proceed in your absence or in the absence of the legal heir of one of the defendant who has passed away?
It cannot.
Then
Therefore, my lord, it cannot because
you have made an endeavor
my
that
lord,
I am the legal heir. I want to get myself impleaded, rejected. And later on, you have shown more than what is required to show your bona fide.
my lord, I have come against the order of rejection, my lord, because that's because in a partition suit, my lord, the Supreme Court having said every co-sharer ought to be a party because how the decree will be executed. Because in a partition suit, the plaintiff must show that he is the title holder of that property. Sought to be
Your right has germinated on the death of your mother or prior to death.
my
Tell
lord,
us.
my after the
After the mother. No, you'll be substituted if he doesn't file an application for substitution. Sit tight. Enjoy the show.
No, my lord. Then after the decree would be passed
How can a decree be passed
against
without
because,
substitution if there's a legal error? You have already shown that you are a legal error.
because the suit there is an order of ex parte against my mother.
Ex parte or inter parte?
If I no, my lord, if
Ex
I
parte or inter parte, partition suit, you may contest, you may choose not to contest. That will not make or take away the requirement of law to substitute a defendant who has passed away.
but if I am impleaded, my lord, if I file an application under order 22 rule 4, my lord, what will be
No, Mr. Roy, we are not against your for adjudication of the matter before us.
Lord.
We are only thinking on a broader perspective
The lordship is right.
that whether you needed to even make an endeavor to the court to implead yourself. Was it necessary?
Because the court will let us say, my lord, when you knew, why did you not I will not get you.
Where is the law?
No, no, because I have
You
already.
have said it is the duty of the
No, but
of the plaintiff who has come to the court, plaintiff or appellant or
And
petitioner, that
There
one.
may be, but I had a remedy. Why did I not take the remedy in a higher court? Therefore, not I.
No, you did not. You were not to take any remedy. Somebody has passed away. Let them. It's their duty, their obligation to file substitution application.
In
Where
fact,
is that order? 76.
oh my lord, it is page 76.
What
My
is the stage of the suit now?
lord, my lord,
Suit is of the year which year?
argument stage. But then,
2012.
my lord, it happened like that. Suit is an argument stage. I admit it. But now the last order, the defendant number, the advocate for the defendant number 1349 retired. So fresh notice has been sought on them. So it will go again.
Hearts-free Picaro Land Senior Counsel for the petitioner who has filed this petition under Article 227 of the Constitution of India, challenging an order dated 10/5/2024, passed by the learned civil judge, Senior Division Number 2, Silchar, in Ms. case number 24 of 2020,
Because
arising out of title suit number 16 of 2012. Full stop. Para. The projected case is that the mother of the present petitioner, please have your seat,
Lord,
was arrayed as pro forma defendant number 27
Lord.
in the aforesaid suit filed for partition. Full stop. The service of notice upon his mother is one of the issues which has been raised. Full stop. The suit has proceeded ex parte against the mother, who however had passed away in the year 2018.
2018,
you had said?
no, my lord, it's 19. 10/6/2019.
You said 18.
Oh, no, my lord, 19/12/2015.
15. You had said 18 at that
I'm
time.
sorry.
The-
Yes,
2015.
Lord.
2015. Full stop. Para. No, para no, actually. Accordingly, the petitioner had filed an application under Order 1, Rule 8, within bracket A, read with Order 9, Rule 7, read with Section 151 of the CPC, which was registered as Ms. J case number 24 of 2020. Full stop. Para. Para na lage actually. By the impugned order, comma, impugned order dated 10/5/2024, comma, the aforesaid petition has been rejected. Full stop. Para. The London Senior Council has submitted that the provisions of the code, COD, under which the petition was filed may not be correct. Full stop. However, the substantive relief which was sought for was only to give a fair opportunity to the petitioner and for proper adjudication of the lease before the learned court. Full stop. It is submitted that without appreciating the aforesaid aspects, comma, the impugned order has been passed. Full stop. Para. Let notice be issued, returnable on July 19th, 2024. Let steps be taken for service of notice upon the respondents by registered post with AD. Steps within 3 working days. Full stop. Para. The suit is of the year 2012 and is stated to be at the stage of arguments. Full stop. However, due to retirement of certain counsel, comma, notices have been sent, full stop para, under those circumstances, comma. The hearing, the consideration on the interim prayer is deferred to the next returnable date. You serve.
Huh? My lord, next date is 8/7, my lord.
8/7 is for notice of
Lord,
council.
My lord, till then, my lord, till then.
No, we are not saying. You come, there we'll see. We have not declined.
My lord, your lordship has given the 19th, my lord.
19th. You can
Let it
give
be-
any other
let it be
date
2 or 3 days later, my lord.
on 22nd.
22nd.
19th is a Friday. We'll have it on Monday, then 22nd.
Lord.
Okay.
Again, for time being.
My lord, this is against the order of my lord, the learned trial court, whereby the my lord PW evidence has been declared as expunged, my lord, because non-appearance of the PWs before the my lord advocate commissioner.
Petitioner is what? Defendant.
Plaintiff, my lord,
Petitioner plaintiff.
my lord.
Suit for
Good for my lord, right title interest and for and permanent injunction, my lord.
declaration, right title, interest,
And-
permanent injunction.
Yes, recovery of possession and
Recovery
permanent-
also.
Yes, my lord, recovery is there. Because the lane is, good lane is my lord in the possession.
Okay,
of the
then what had happened?
My lord, then my lord, the defendant appeared and filed a WS,
Oh, WS filed.
file, my lord. And
How many defendants?
my lord, 6 defendants are there, my lord.
They have filed. They have filed jointly.
Yes, my lord.
Okay. Then
Then subsequently, my lord, PW has been filed.
You-
Evidence of the plaintiff has been filed, my
how
lord.
many?
My lord, PW
You would
1
file
to 4, my lord.
1 to 4. File affidavit on evidence.
Yes, my lord. Then, my lord, the trial court, my lord, fixed the matter for evidence and forwarded the matter to the advocate commissioner, my lord,
For cross
for
examination.
cross-examination. Fixing a date, my lord, on that day, my lord, fixed for cross-examination, my lord. The engaged counsel of the plaintiff, my lord, could not-
Just a minute. Which date was fixed?
my lord, 25/1/19,
25/1/19.
my lord,
2019.
my lord.
Yes.
There, my lord, on that day, my lord, on that day, the engaged counsel of the plaintiff, my lord, could not make any contact with the commissioner, my lord.
Oh.
So they, on that day, my lord, no cross-examination was done.
Did you appear?
My lord,
Did you appear?
the trial court.
No, did you appear? Did the plaintiff appear for their
No, my
cross-
lord, they could not make any contact with the my lord, learned advocate commissioner.
Advocate did not inform the date.
Yes.
None of the plaintiff witness could appear.
My lord, could appear, my lord. And my lord, on 14/3, my lord, of 19, the learned, my lord, advocate commissioner, my lord, submitted a report for non-appearance of the plaintiff witness, my lord.
Mm.
Accordingly, my lord, on 14/3/19, the learned trial court, my lord, passed this order, my lord. Lordship may kindly see page 32.
32.
Annexure 3, my lord.
Yes.
What are dated, my lord? 14/3/19. Both
Hmm.
sides are represented. Seen the report of the commissioner stating that the plaintiff side has not made any contact with the commissioner and so cross-examination of PW could not be conducted. In view of the report, the cross-examination of the PW was closed and the evidence of PW was expunged and the same shall not be appreciated. My lord, in between that, what happened, my lord? The learned, my lord, the plaintiff disengaged the engaged counsel, my lord, in the trial court. So on 14/3, my lord, new set of counsel has been engaged. And only, my lord, what they have did, my lord, they have did only, my lord, file Hajira, not file any petition regarding that absence time. So
On
this
14/3.
on 14/3.
No, see, 14/3, the order was passed on 14/3.
My lord.
Till 14/3, there was no order for expunging your.
Yes.
So the order for recall would only be petition for recall can only be filed after 14/3, not on 14/3.
That is true, my lord. My contention is, my lord, on that day also, my lord, The engaged counsel of the plaintiff, my lord, did not inform the court that on the day fixed for cross-examination, they somehow could not, my lord, present. That was not
They did not
intimated.
pray for a further time.
Yes, my lord.
They could have.
Yes.
Before passing the order of expunging.
Yes, my lord. Yes.
They could have prayed for time to give another
Yes.
opportunity.
Because
Okay.
on that day, my lord, plaintiff engaged another set of counsel.
Okay.
Subsequently, my lord, this new set of counsel, my lord, filed an application, my lord, under section 150 on CPC, my lord, for
Page.
recall.
Page.
My lord, page 33, annex 4.
Yeah, yes. Yes.
My lord, the explanation is at page 34, my lord, para 3, my lord.
Yes.
Para 3 is there, my lord. It is stated that after filing PW, the engaged counsel tried to contact the learned commissioner over telephone, but he failed to contact and nor meet the
Okay.
learned.
Thereafter,
My lord, annex 8, my lord, page 40, my lord.
40.
40.
Yes.
So, my lord, this is the impugned order, my lord, whoever the petition
This
for recall.
petition was filed when? 151 petition?
This one filed on, my lord, this was filed.
On 6th of May
Yes, my lord.
2019.
Yes. 6th of May.
Then what happened? What order passed in page 40?
Then, my lord, page 40 is the order, my lord, against their recalling petition, my lord.
3110.
Yes, 3110.
Yes. Yes. What is the order passed?
My lord, para 3, my lord. For invoking the provision of section 150 of CPC, one must show that there is any abuse of process of the court. Here, the case is that in the default on the part of the counsel for the plaintiff in not making any contact with the commissioner, and that by itself is not abuse of the process of the court. Further, that for appearance of the witness are fixed by the court, and the parties need to adhere by such order. But in the present suit, it reveals that the plaintiff or his witness did not appear before the commissioner, and so that claim of the plaintiff is not accepted. Further, the discretion to be exercised under section 150 of CPC is not a matter of because a party filing any petition under
Prayer has been rejected.
Yes, my lord. So against these two orders, my lord, this present petition has been filed. My lord, my prayer is, my lord, only for one instance, my lord, the plaintiff, my lord, has failed.
Which two orders?
My lord, this 30, 10, 90, 31, 10, 19, and my lord, for 14, 3, 19. 14, 3, 19 is the order, my lord, whereby the PW evidence has been expanded. Page 32.
When did you file this?
My lord, this matter has been filed in, my lord, 22, my lord, in the year 22. But, my lord, somehow there was some defect. My lord, the plaint of this petition was not clear. So we have instructed to, my lord, bring the plaint, my lord. Plaint is, my lord, at page, as you may see, at page 18, my lord. There was some defect, my lord. That's why there's some delays in the judgment.
22, if you even got filed in 22, impugned order is of 2019.
My lord.
Are you years to rectify the defect?
My lord.
You filed the petition after 2 years. From 19 to 24, how many years? 5 years have gone past. Are you having contact with your clients or not?
No, my lord. Recently, my lord, they have given this copy, my lord. That's why we have rectified it, my lord. Now, my lord, as per my instruction, the defendant side also not appear in the trial court. Now the matter is pending in the trial court. The engaged counsel or defendant also withdraw their wakalat nama.
It will not make any difference if
My
you do not establish your case by adducing evidence.
lord.
It is not on the basis of the plaint.
My lord.
At least somebody has to stand
Yes,
on the witness box and say, verify the statements.
my lord.
Even if you do not exhibit any documents or anything else, at least you have to make a statement on oath.
Yes, my lord.
What purpose will it serve? Defendants are not appearing. Here notices will remain unserved.
My lord, now as per my, the matter has been fixed for, my lord, PW has been closed because they are not appearing. And matter has been fixed for argument, my lord. Only my prayer is, my lord, if this PW has not been considered, my lord, this matter may be in fact, my lord. The suit of the plaintiff may be in fact.
The suit will go now. PW has been closed. It was closed in 19. You filed in 2022. You had a new set of counsel who had appeared on 19. 14/3 March.
My lord.
Suit was for suit at right and interest.
Yes, my lord.
What was
And-
the suit property?
My lord, suit property is, my lord, Trustee may kindly see at page 27, my lord.
Even if you file it under 227, it has to be treated as a revision petition. There will no limitation will come in.
No, my lord.
Hmm? Can powers of 227 can be exercised by wholly ignoring the aspect of laches, at least, if limitation no. Laches is still there. Heard SHRI case in a learned counsel for the petitioners who by means of this application filed under Article 227 of the Constitution of India has put through challenge order dated 14/3/2019 and 31/10/2019 passed by the learned civil judge number 1 Kamrup M in TS number 8 of 2016 full stop. By the first order, comma, the evidence of the petitioners who were the plaintiff in the suit has been expunged due to their non-appearance, and by the second order dated 31/10/2019, the prayer for recall of the aforesaid order dated 14/3/2019 has been rejected. Full stop para. It however appears that the present petition was filed on 22nd of June 2022, and when it was found that there were defects, full stop. The defects have been rectified recently, whereafter the case was reported on 7/6/2024. Full stop. Para. Let notice be issued, returnable on July 17th, 2024. Let steps be taken for service of notice upon the respondent by registered post with AD steps within 3 working days. Para. The maintainability of this petition on the ground of delay and laches is however kept open. Okay, right. We'll take a break of 5 minutes. 13. Para 9 is relief clause.
सर पैरा 10 सर देखेंगे पेज 65 में वो इनका इंटरिम रिलीफ का पोर्शन है.
And sir, IA number is 3624 of 24.
हाँ, क्या लिखा है आपने? टिल
DRT decides on the interim IA number dash.
IA number
IA number 3624.
of 24.
And sir, and interim application number 3625.
IA means we are asking the interim relief application number before the DRT.
Sorry, my lord. 3625.
3625. No coercive steps shall be taken against the petitioner. Next para. This court hastens to add that no comment on merits have been made and the DRT shall be free to decide the prayer for interim relief along with the essay, either way, in accordance with law. Yes.
Chapter or number 1.
Yes, any report?
Sir, we're still awaiting, sir.
Report regarding what?
Sir, factum of the death of the appellant's wife.
Death कब हुई है?
सर 4 तारीख को डेथ हुई. मैंने डेथ सर्टिफिकेट भी फाइल किया जो और एक पंचायत का सर्टिफिकेट भी फाइल किया है और जो डेथ सर्टिफिकेट मैंने पेज नंबर 8 पे फाइल किया है सर. काइंडली सी पेज नंबर 8 पे है सर.
But इसमें you want to be released to do what?
मतलब ये हस्बैंड है और इसके 2 बच्चे हैं छोटे छोटे और इसकी एज प्लान की एज 33 ईयर है. यंग बच्चे छोटे हैं दोनों और सेरेमनी होना है एज वेल एज इनको अस्थि विसर्जन के लिए भी जाना है. सब्जेक्ट टू वेरिफिकेशन ऑफ ट्रायल कोर्ट.
मिस्टर काउंसिल, अस्थि विसर्जन तो अभी तक हो चुका होगा.
नहीं हुआ सर, अभी नहीं हुआ. और ये इनका रिचुअल फाइनल रिचुअल 13वीं वगैरह जो होता है वो भी होना है.
डेथ took place 10 days back.
सर बट 13 दिन का प्रोग्राम होता है सर. 13 दिन का प्रोग्राम.
13वीं कब है?
13वीं है सर 16 तारीख को. 16 को.
16 को.
यस. तो सब्जेक्ट टू वेरिफिकेशन ऑफ ट्रायल कोर्ट. अगर माय लॉर्ड ट्रायल कोर्ट सब
we'll send you in custody. देखिए इसमें the IS also has been filed for temporary suspension of sentence to enable the appellant, sole appellant.
Yes, madam.
Sole appellant to attend the 13वीं scheduled to be held on
15th and 16th.
15th and 16th of this month due to death of the wife of the appellant on 4th of June.
Yes.
Next paragraph. Since the IA had been moved yesterday.
No, madam. IA was filed on 10th June.
Since the IA was moved on 10th June, the verification report regarding the factum of death has not yet arrived from the state side. Next, but accordingly, the IA stands disposed of. The direction to the police authorities to take the appellant in custody to attend the 13वीं.
He is in jail, Bairugarh jail, Ujjain. So kindly direct to the jail superintendent of Bairugarh jail, Ujjain.
No, we don't know where he is.
But मतलब इस ऑर्डर को लेकर के मैं कहाँ जाऊँगा सर?
और उसमें जेल सुपरिटेंडेंट को कर दी. जेल सुपरिटेंडेंट ऑफ
बैरूगढ़ जेल उज्जैन.
बैरूगढ़ जेल.
Yes.
To take the petitioner
in custody to attend the Tervi ceremony and bring him back the same day. Next, list the case in the first week of July for ensuring the surrender of the applicant.
My lord, CC to them.
CC today.
God bless.
So Indore DB list is over.
Yes.
And what about Gwalior? Gwalior is this?
Hello.
Your Lordship, Your Lordship.
नहीं,
इसके नीचे है
ये Gwalior, ये.
Your Lordships, I want to make a request, Your Lordships.
ये तो सब single bench है. Yes. So brother will take up the Gwalior bench DB.
Yes.
ज्वाइन करूँ सर
हाँ. ग्वालियर का तो ये हो गया.
completing his if possible. Let the matter be listed on 27th. By which date the respondent will be able to complete his instruction. Hello.
Lordship, similar matters has been dismissed by this honorable court.
Today, my lord.
Today. There's, yes, my lord. This is before the honorable court in the court.
Dismissed.
Because there is alternative remedies available, my lord.
I had a word with a senior, my lord. A similar order would follow.
Where is that similar order?
My lord, it has just been passed, my lord. I'll give the petition numbers, my lord.
Take it up next week.
Next week.
List on 19th.
Lordship.
19th. June.
My lord.
It is submitted that similar matters listed before court and have been dismissed. Copies of the order and the councils are permitted to place the copies of such order by the next day.
My lord. Obliged, lord.
Also, the petition of given are already there.
You give him a copy. How will he know? Your representations have been considered. Disposed of and dismissed, rejected.
Lordship, we may be given a copy of that.
I'll provide it.
We close it.
Close it.
Lordship, 1 week time may be given to at least see what is there.
Also, already the 10 years of
We are taking up at 2 p.m.
Lordship, 2 p.m.
At 2 p.m. It would double the money. And appears to it's after a week.
The last occasion, respondent sought time for filing affidavit matter.
Who's for the respondent? Gal.
Gal affidavit matter.
The Mishra appears for the writ petitioner. The respondents are permitted for the 2 weeks time. 3 weeks time to complete their instructions and file necessary affidavit. And as Purva, you appear in the matter?
Yes, sir. I am for
one.
Perhaps you don't appear.
One. I have for 1, 4, and 5.
You are for you are the CGC.
No, Lordship. State government.
One is Government of India.
31. 31.
Oh, sorry. Obliged.
The respondents are permitted to file their after affidavit further or within further 3 weeks. Matter will be again on 15th of July. Interim order passed earlier will continue.
Deeply obliged, my lord. May I please, Your Lordship, in item number 30, Lordship, I was in another court. A matter regarding
30. We have directed it to be listed next week. Will come next week.
Lordship, SGC matter maybe Lordship dispose of that. Because matter pending 2022 matter.
Who's for the respondent ex gratia item 30?
One query at
Kamrup Rural. At Kamrup.
Deputy Government inquiry is eligible to get the benefit then.
Joseph, I have another item number 33, same item.
33.
Their petitioner is the mother.
Proposal have submitted to the government lordship already.
So let the government take a call on this matter. Heard. Submitted by the on instruction that the DC Golaghat has completed an inquiry and in favor of the petition
Yes, the proposal had to start.
for release of equity as per the scheme. It is submitted that the matter is pending to the department to get even regards to manage. Accordingly, the direction pass a clear order and period 60 days from today. Like 90 days from the date of receipt of such department to pass the proposal stated forwarded by the
Much of it.
I am for 3, 4 and 5.
There's Bura, Red 5, and Yarwan.
Keep the
My lordship, in this matter, I'm standing as a legal aid counsel. Earlier, different counsel was there. The last occasion, the list of dates that it is available. I'm not handing over it. If my lord would kindly have it for a moment. We'll skip it for a moment, the first page.
Yeah.
The basic issue is the second page. The application for scholarship, post-matric scholarship was given. And there was a recommendation of scholarship also. The dates are given in bold. Now, at that period of time, there was some complaint against the petitioner, considering his caste status. However, in the meantime, the first installment was released. That is 2617, 11,44,000 odd. And this is the utilization certificate also given. Now, the second installment was released the next page. 11,10,17. Utilization also given. It's about a pilot license. He was a member of the SC, given some scholarship. However, in between the second and the third, there's a 40 months gap. Lordship is there. There's a 40 months gap. Now, there was a speaking order on the complaint against the petitioner. That a state level scrutiny committee comprising so and so that it was affirmed that the petitioner belonged to the scheduled caste. And so the third installment was released belatedly on 17/2/21. In the meantime, he somehow had to manage, bearing all the loss, because this delay had a consequence. That is next page, Consequences of a delay. What is there?
Yes.
Petitioner could not apply for the next due scholarship on time. That is the Airbus A320 type rating scholarship for the Ministry of Social Justice and Empowerment, Government of India. Due to inability to complete the type rating course on time, petitioner could not apply for various vacancies of co-pilot first officer position for Airbus A320 aircraft, Air India, and
under the reserved caste category. So
He's what, employed now? No,
he's unemployed.
he's unemployed.
He's unemployed.
He
No.
doesn't have the license.
He has a license in part, but he's unemployed. Because of the delay of 40 months on a vexatious complaint on his caste status, these things ensured
But why is he unemployed?
he could not get a job on time because he missed the entire thing for delay. Now he lodged a complaint, Vivek,
No, no,
on
is he-
22/3/22.
Does he hold a valid qualification?
So he has a license.
He has the license.
He has a license.
If he has the
Commercial,
license-
Commercial license.
commercial license of private pilot.
Now we have different thing altogether.
Commercial license.
He's working.
No, he's not working.
Regarding working part,
No,
I have
this
no
is-
knowledge. Otherwise, he's a commercial license for pilot license, Type 2 lordship, domestic airlines lordship.
So how come you're unemployed?
Lordship.
So he's not working.
He's a commercial license.
He's not working. He's not working. Now he lodged a complaint in the National Commission for Scheduled Caste.
Hmm.
That is on 22nd of March 22.
Yes.
Now, the National Commission for Scheduled Caste passed a final order on 9/9/22, directing the police department to reinvestigate and arrest the person who made false complaint against the petitioner, which eventually led to delay the process of scholarship to the petitioner, and also directed that appropriate direction be taken against WPT and BC department, who ordered for reinvestigation of the caste certificate of the petitioner. It was also recommended that for the huge loss incurred by the petitioner be given compensation accordingly. This was a direction at page 147, 148. Now, the entitlement to compensation. A person who registers a case under the SC/ST Prevention of Atrocities Act 1989 is entitled to get compensation under the Trade Rules of 95 as amended by notification. Therefore, my lord, this prayer was made in the writ petition A, B, and C. Direction for the authorities to take action as so directed by order dated 9/9/2002. This is the first one. Second one, lordship must keep for a moment. This would be different. The third one would be direct Deputy Commissioner Kamroop Metro to release statutory compensation and prayer for direction to pay interest and compensation amount. What we say is that let them take a call at page 147, 48. Lordship takes up the petition now. No, I have not drafted it. It is not so happily worded, my lord. Page 147, 148.
All petitions are happily worded as far as we are.
Otherwise, lordship, the regarding maintainability part, lordship, honorable court had last two occasions extensively hard lordship regarding maintainability or a repetition,
A
lordship.
person who is scheduled caste,
Lordship.
born scheduled caste,
That part was already
regardless
discussed,
of his
whether this pair can be entertained by the
Absolutely,
district
Lord.
court or not, that part was also honorable court question solved.
Well, if I may address with all humility,
No orders passed.
No orders passed, lordship, but it was the deliberation of the honorable court, lordship, last more than 3 occasions. My friend
Yes.
can
the
apply.
only thing which came in ways was
Lordship.
if a person is born as a scheduled caste, whether he gets a protection on the act so that he can avail the legal aid. And the direction was given to the department concerned of the Honorable High Court, and they put up a note also that yes, entitled. The financial status is not a bar.
Why is it not maintainable?
They say because you had pursued a commercial path, like otherwise you might be not so poor. And I say financial status has nothing to do if I'm a scheduled caste or a woman or those, the list it mentions for grant of legal aid.
Otherwise, one of the query of the honorable court is that whether this court can executing court or not. That part regarding compensation.
So
part.
far as the other part is
Compensation
concerned,
part, honorable court, that query was also put to the petition.
yes.
And that part also considered.
So far as page 148 is concerned,
You filed your
See, our affidavit is not required as this government, state government WPT affidavit. I am representing the central government, lordship. The official deliberation before the honorable court, just I pointed to, lordship. And probably WPT's name is not shown in the cost list, so my.
but I believe he's representing the National Commission for Scheduled Caste. Well, if he's representing the National Commission for Scheduled Caste, I put a question to myself. If it's a direction by his client to pay compensation, how can he make a submission against me? Not?
I am not submitting against
Absolutely,
that.
he's in
but
favor.
Whether that order can be executed by the High Court or not. That part was court has lordship would query to the
that
petition.
will have to be
Lordship.
that will have to be objected to by someone who
Lordship.
is agreed by that order.
Lordship.
You
And
have
that-
passed this order, how can you be agreed by that?
Lordship, I am not agreed there order. Just I am pointed out what is the deliberation before the honorable court, lordship. It is my duty, lordship, to point out what is happening in the
Absolutely.
earlier occasion, lordship.
Absolutely. Yes.
Then, lordship, one point of time, lordship, honorable court number 70 has wanted to impose the cost also, lordship.
A person who comes on the legal aid cannot be given cost.
It is the view of the honorable court, lordship.
So the Therefore, the question: if you are holding a commercial pilot
Yes.
license and you
No,
why
no,
are you
this is
conducting?
very fair. Ultimately, the concerned department was asked to look into the matter and put a note was put up. It's there in the file. But the legal department, I said I had been engaged by them. I had nothing to do with this. You keep me here, you keep me out. So the department was put. I can address in a legal issue that financial status has nothing to do if you are otherwise entitled under the act.
Yes. So, but whether legal aid has been granted, not granted, is a different issue.
No,
No, they raised that part. That was raised. It was a question which had come for consideration, my lord, that whether you are entitled to legal aid otherwise.
All right.
The criteria for giving
Finally.
legal services, my lord,
also it's a
a member of SC or ST.
WPT department, Lord.
The criteria for giving legal services, every person who has to file or defend the case shall be entitled to legal service under the act if the person is a member of scheduled caste or scheduled tribe. A lot more, my lord. So,
WPT name is
financial
not
state has
shown
nothing to do with it, my lord.
in the cost list law. WPT department name is not shown, laws.
He is representing an
No, no,
article matter.
no.
Yeah,
So who was directed to make the payment or?
my lordship. Page 149. One 49. After hearing both the party in detail, it is found by the commission that additional secretaries who had appeared in the hearing have delayed the matter intentionally, which could have been settled at their end. The purpose of post-matric scholarship for scheduled caste students was totally defeated due to negligence of the concerned officers, which led to undue hardship to the petitioner, and he had to sell his land and mortgage his property to pursue his studies. The commission recommends the concerned police department now to reinvestigate and arrest the person who made false complaint against the petitioner, which eventually led to delay the process of scholarship to the petitioner, and appropriate action be taken against WPT and VC department who ordered to reinvestigate the caste certificate of petitioner. Due to this, the petitioner incurred huge loss. The commission recommends that petitioner may be given compensation accordingly. Accordingly, action taken report be submitted to the commission.
This is a recommendation after.
No.
It's a recommendation.
However, lordship views, I only have to point out.
No, no.
Yeah, I understand. A recommendation and direction may be different.
If it is a recommendation, does it give you a right to be enforced?
There is another view also. This is not a challenge. It says recommends that the commission is in affirmation,
Yes.
In affirmation.
State.
SC WPT is
No, no.
required.
Police department is there. Commission is there. Who is there? Who's for WBT?
Ardhar is applying for
Please call him.
WPT.
Please call him. We'll again take it up at 2. Take it up.
My colleague was earlier appearing for a particular department. He has given me a notification. So there has been bifurcation or trifurcation. So perhaps I need to.
I told him that, my lord, this SC now will fall in the domain of social justice and empowerment, my lord, after 2022. That WPT-BC department is no longer, my lord, in existence.
So you represent that
No, my lord, RM Das will represent, my lord, that social
I
justice
have
and
to
empowerment.
He has to lordship
Complete.
first amended the
First the amend the cause title, make them a
Then
party.
lordship.
I mean,
Naturally.
to, this WPT was added later.
No.
At the early point of time, my lord. And my lord, and my name is also not shown. I am not.
WPT is already a party here.
Oh, yes. R2.
You have some notification.
Yes, my
He
lord.
has given me.
I have given it to him. My lord, soft copy, my lord. Just I got.
You hand it over to the court
Okay.
martial.
Yes, my lord.
It is submitted that WPT and BC department of government of Assam has been bifurcated into
Three departments, my lord.
3 departments, 1, 2, 3, in terms of the notification dated
Dated 2nd November 22.
2022.
So appropriate department came
Copy of the same has been placed before the court. So the grievances of the writ petitioner will now be required to be
Department of Social Justice and Empowerment.
Will be looked after the proper respondent
Directorate.
in respect of the grievances raised by the writ petitioner is now the Department of
Social Justice and Empowerment.
Social Justice and Empowerment. Accordingly, in view of the submissions made, let the Commissioner and Secretary,
Commissioner and Secretary, my lord.
Department of Social Justice and Empowerment,
And Director SC and OBC, my lord. The directorate.
Department of Secretary, Commissioner and Secretary, Department of Social Justice and Empowerment,
And
Government of Assam,
Empowerment.
and
Director Scheduled Caste and OBC.
Scheduled Caste and OBC. Department of
No, my lord, this is directorate.
Directorate of
Scheduled Caste and OBC Welfare.
Directorate of Scheduled Caste and OBC. The arraigned is party respondents, either side. The petitioner will file amended post title within 2 weeks and furnish extra copies to the concerned.
RM Das is the Mr. RM Das.
It is submitted that Mr. RM Das and Council represents the newly pleaded respondents. Accordingly, let notice be issued to the newly pleaded respondents returnable by.
It should come after vacation. He has to file a
by 3 weeks. Meanwhile, the petitioner will take steps by service.
No, we'll by hand. We'll give to the council.
Listen to the order.
Take a step.
By service of copies on the standing council, Mr. RM Das, along with a copy of this order.
Your Lordship, I am representing 6 and 7.
Sir, he represents 6 and 7. Anyone else?
No.
Purva 4?
Deputy First.
1. 1, 4, and 5. Respondent number 3. Sorry, the respondent number 2 and 3.
20 was Dhod.
Mine.
Are no longer required to be arraigned as party. And their names are struck off.
On that written list of dates is given as per court's order, that may be indicated.
The written list of dates given furnished by the counsel to the petitioner is retained in the case.
Gotcha.
Yes, covered.
Lordship, it only addresses one aspect of our prayer, Lordship. Actually, our main prayer was to hold the elections of the body.
No,
Lordship.
That has already been
But this order
scheduled.
does not indicate when the election.
No, that there was a time frame given last day, 9 September or something like that. No,
That is another case, Lordship.
oh, another case. Sorry.
Also, his pay already did this, Lordship.
Because our prayer was, Lordship, to hold the election to constitute a fresh committee.
No, there
or
is
if
no,
not,
Lordship, there is no pay as
So
such.
you have had a prayer to direct them, the respondents, to consider your
Lordship.
representation
yes,
and thereafter to extend the term.
Lordship, our representation talks about holding elections, Lordship.
That has been rejected.
That is rejected, Lordship.
That has been rejected.
But election they'll have to do, Lordship. That is a mandatory.
That you put
statutory.
to challenge if
Lordship,
you want.
Lordship.
You
That
put
is a
to
part,
challenge this writ petition, this order if you want to.
but
As
Lordship,
far as this writ petition is concerned, the prayers have already been.
Already it is.
that is only a part of it, Lordship,
No, no.
because our prayer for holding election
No,
Where?
there is no pay for holding
in
election.
the Lordship synopsis itself,
No,
Lordship.
show us in your prayer. In your
And
prayer, page number 11,
Page number 11.
11, 12. 11, 12, it is for disposal of your representation and
Lordship.
extend the term.
And our representation is asking for holding elections.
That has been rejected by this order. If you are aggrieved, you have a right to challenge this order.
Lord. Then Lordship may
That
give
is
us
what we are
liberty
trying
to.
to make you understand for 1 hour. Third learned counsel for the parties is a writ petition is filed by the petitioner who claims to be the chairman
Lordship.
chairman of the
Guwahati Sub-Divisional Market Committee.
Sub-Divisional Market Committee constituted under the Assam state, constituted by the state of Assam under the provisions of the Assam Agricultural Produce Market Act 1972.
72.
During the pendency of the writ petition for apparent, it is submitted by the learned standing counsel Market Road that during the pendency of the writ petition, by order dated 9th of February 2024, the representations came to be considered and the same has been disposed of. Same has been rejected.
Also, we have served the copy to the petitioner on 22/2024.
So, in that view of the matter, the prayer in the writ petition for disposal of the writ petition has been reduced by the Department of Agriculture. So, it is submitted that copy of this order has been served on the writ petitioner himself. That view of the matter, the writ petition stands closed. While giving liberty to the writ petitioner, challenge the order dated 9th of February 2024, even though they would be done properly. MS is for Agriculture Department. Sir, Hormone Board.
On behalf of Mr. J.K. Goswami, spending council letter.
We have Mr. J.K. Goswami standing. Writ petition stands disposed.
I'll do this.
My lord, this is also a ecclesia matter. My lord, petitioner husband died. Husband.
We dispose it off.
Yes, sir.
Make an inquiry. For
Deeply obliged.
Like 55 and 59 will be taken together, my lord. Because both the cases are, I think, out of same FIR. 59. My lord, the FIR at page 25. 3% right.
You're asking for what?
Compensation under public law remedy method. Because my lord, 3% right while they are working
Compensation from whom?
from the government. My lord. Because my lord, the 3% right for the fault of the departmental authority.
Where is the finding?
Finding my lord, FIR itself clarified my lord. The department.
FIR?
Yes.
What is this?
Page 25 my lord. We have not filed FIR my lord. The executive engineer has lost the FIR. Page 25. Second paragraph my lord.
What has the government got to do with?
My lord.
What will the government do?
Government.
You are employed under the contractor.
No, my lord. We are not employed, my lord. Here, my lord, the victim was a minor, my lord. But he was engaged by the contractor as well as the mason, my lord.
So it says 3 numbers of labor.
3 numbers of labors are died, my lord. So, yes, my lord. For the fault of the contractor and the department, my lord, kindly come.
Who are you?
My lord, I am the father of one of the deceased, my lord.
One of the deceased.
Yes, my
When you
lord.
say minor?
Yes, minor, yes.
Minor?
Yes, my son was minor, my lord. Below 18 years.
So under what provision will the state give you compensation?
Under public law remedy, my lord.
Public law, where is the responsibility of the state? State has not engaged a minor.
My lord.
It is the contractor.
Yes, my lord.
You have filed FIR is against him.
We have not filed the FIR.
may not
The
have-
executive engineer himself filed the FIR. My lord, come to page 20, my lord. The work order, my lord. Then follows 12 and 18.
12 and 18.
Page 21. Third party inspection. Third party inspection agencies engaged departmentally will have the liberty to inspect the executive works,
What is
construction.
the status of the case? FIR.
And then, my lord, clause 18, my lord. Minimum on technical person must be deployed at the execution site who shall be treated as the field level point of.
Counsel, you are claiming from the state when
Yes.
it is the contractor who is responsible.
Yes, my lord.
Have you made him a party?
Yes, we have made party.
Who is appearing for the contractor? What do you say? You want to file affidavit? Then who is 11?
I am on behalf of the
Who is 11?
Elementary labor is my.
Why is he made a party?
He is the mason, my lord. 11 is the mason.
How is he responsible?
Because, my lord, the contractor and the mason engaged the victim.
Is this respondent 10? Who is the respondent 10?
My lord, 10 is the conductor, my lord.
Conductor?
Yes.
Conductor of what?
Who was get the works, my lord. Page 20, the work order, my lord.
So conductors are normally found in the past, collecting tickets. There.
Yes.
You are referring to the contractor.
Contractor, my lord. That's sorry, my lord. Yes, spelling is contractor.
All right. Third level completing parties. MS so and so, learned council appearing for respondent 11. 10. Surface that she would like to file an affidavit.
And I am
DC on behalf of 11.
Huh?
DC now.
Not appears for respondent 11. You want to file something? Respondents are permitted to file. What about 59? By another person?
Oh, another person.
Then similar order?
My lord, criminal.
But you'll clarify whether he is a conductor or a contractor.
Contractor. Contractor. I may be allowed to correct to enter.
In the presence of the court.
Yes.
Correction.
Problem. Problem. 36, my lord, for ex gratia, my lord, the husband of the petitioner died in a motor accident. Thereafter, the petitioner
Verify and pay?
FIR.
Verify and pay?
Yes, that's it.
To be verified?
Yes, verified there. And it is falls under the jurisdiction of District Commissioner Amin Gao. And the application sent to that Amin Gao.
Where is that application?
Page 27, my lord.
So it is that DC Amin Gao.
Yes, that's it. Falls under jurisdiction of DC Amin Gao.
So
And application made to DC Dorong Mongol.
No. Deputy Commissioner Kamrup.
No, page 27.
Page 27.
From District Commissioner Amin Gao, instruction not received, Lordship. Matter may be disposed of by directing. After verifying that.
Where did the accident occur? By Hatasari.
By Hatasari.
Where is the scheme? Have you enclosed a copy of the scheme?
Page 14, my lord. Page 14. Serial number 3, my lord.
So who is to make the inquiry?
My lord, actually, accident at occur, my lord, under Kamrup, Amingao district, my lord. Rural, Kamrup
Your
rural
FIR
district.
says it is by Hatasari.
By Hatasari is
By Hatasari.
yes, my lord. Kamrup rural, my lord.
Then why did you file it before wrong?
No, my lord, we have filed before the Deputy Commissioner Kamrup rural, Amingao, my lord. Accident occurred under Kamrup, Amingao, my lord. Problem.
Yeah.
Okay.
Item 38, 13 and same, my lord. Your lordship already disposed of similar matter, my lord. Yes. In that case, my lord, Patna, my lord, it was given, my lord. It was mutated. Subsequently, my lord, it was, my lord. Again, my lord, cancelled, my lord.
Who's for the respondent?
My lord.
What do you say about this matter? Have you
All-
seen this order?
Yes.
You have seen this order?
No,
Which order?
Yes.
Just say it is on the same line. Yes. So say in that.
I have Dag number Patna correct.
Lordship has passed it.
Minus.
38, 39.
38, 39.
Yeah.
Item today, my lord, on instruction, I want to do it.
The day Ahmed press the repeating order and therefore same. Dismiss press interim order, the many vacated. It's who appears for the respondent?
I am for 9 and 10, my lord.
Yes. Anyone
Nine
else?
for one.
Keep your name. Keep your name. Give the names in the chat.
Hello.
First is matter pertaining to my lord, issuance of NOC for building permission. my lord.
Sorry?
Building permission.
Yes.
My lord, the respondent was sick as the raised objection, my lord, before the authority. The test said the objection hasn't been managed, my lord.
You are for the
Respond number 6.
who's for the GMC? So it is for
Nagaon GMC.
Nagaon.
Municipal.
Nagaon Municipal.
My lord.
Who appears for Nagaon Municipal? You are appearing?
Yes,
What do you say?
Lordship, 2 weeks time may be given to file it.
Third learned in terms of the order of this court passed dated 2003-2024. Custody was affected on respondents 7, 3 and 6 and an affidavit that affected filed. And Mr.
NM Doctor.
NM Doctor.
Yes.
Appears for respondent number
3.
And Mr.
PW.
PW
Number
appears
6.
for respondent number 6. Mr. N. Bora for respondent number 1 and 4 and 5. The respondents are permitted to complete their instruction by necessary capital within a period of 3 weeks. They stop the 3 weeks. Yes.
May I please, Mr. Lord?
Yes.
My lord, the petitioners are possessing both the brothers, my lord. Now, before a lordship for the inaction on the part of the police, my lord, though we have, my lord, hesitated before the highest authority, including the DGP also, my lord, for the illegal trespass of our land, in spite of some civil court's order are there. Now they are doing criminal acts, my lord, for dispossessing us. So, my lord, the police has not taken any action, my lord. That's a
Yes. Who's
very,
for the
very limited
police?
prayer, my lord.
Home Department.
Mal.
What affidavit nahi
Instruction. Perhaps notice has not been issued in this case, my lord. It has been wrongly come in the admission column, my lord.
Maybe.
Okay. 4 weeks. Yes. 1, 2, 3, 4, 5, 6. Steps of response 7, 8, 9, 10, 11.
11.
5 next month, 8. Within 1 week from today,
Mal.
last is also committed.
Mal.
After return.
My lord, may
If the petition are undertaken, that's included the registry of the High Court. Then affidavit of compliance is directed to be filed thereafter.
Lord, may I pray for an interim, my lord, that the police may protect us, my lord. Obliged.
My lord,
Yes.
this case can be disposed of by it is a covered case, my lord. In my case and the case already decided by this court, seem to be, my lord, of the protocol same nation. Exactly every point, every word is same.
My lord, I am the petitioner. Let me start the case.
I am.
My lord, what had
And I
happened?
will file for vacating the application, my lord, because yesterday, chairman and of course, there is order of a lordship's joint signature. We do 4 crore rupees from the bank, I'm told. So if that goes on, my lord, some restrictions should be there.
My lord, these are all unsubstantiated submissions which are being made. My lord, in their affidavit, there is nothing of that sort. My lord, they have filed an affidavit day before. It has been 2 days probably, day before yesterday, or they have filed an affidavit and an IA. Now, in their affidavit, my lord, they have come up with some serious allegation of suppression of facts on my part, my lord. Now, my lord, I would have argued I intend to file a reply to that, and I will demonstrate before your lordship that who is misleading the court, my lord. Because their affidavit is nothing but a bunch of lies, and where some manufactured documents are annexed, my lord. I can make my submission right away, but I want to bring it on record, my lord.
Yes.
My lord, there should be some restriction, my lord, and withdraw the fund.
Restrictions
Today
are
is the
there.
case fixed, my lord. Yesterday they withdraw the money.
Restrictions are there.
You have filed the
Affidavit of-
Yes.
What are you?
For
vacating of the interim order.
vacating and modification to the extent indicated in the prayer.
I'll file a reply to that, my lord, a short. Maybe on 26th, the lordship may
Page-
take it for
page 10 of
final
the IA.
disposal. I'll file everything.
Put it up in the vacation court available.
Vacation court, my lord, we will not be there. Probably senior.
Right. It is so urgent, we put it in the vacation. We can't say that 26, 27 be possible to dispose of it.
My lord, immediately on reopening.
Reopening is not right.
But
Immediately on reopening.
I think the order passed, if there is so, my lord, then the order passed by your lordship that the EO and, my lord, the chairman can withdraw the money. There should be some restriction, right? Let the deputy commissioner, district commissioner also be.
My lord,
Because otherwise,
this is the
19 crore has
allegation.
been sanctioned.
My lord,
19 crore out of that, they are going on. By the time they are finished.
there is no mention
There
in
is
their
7
affidavit
crore
to that extent, my lord.
allegation of 7 crore
When
embezzlement
matter
by
is
the
called
state.
upon this.
It is submitted by the
And second resolution, my lord, what they have done? The second resolution not annexed intentionally. Whereby I have taken charge.
Like by the fly.
You can go just to go to the getting out of we are giving reply. What
Your
about
respondent number?
I am for the IA.
No, in the IA.
IA. In the IA is not even numbered, my lord. IA, I am
No, it
for,
is number 1851.
I am for respondent number 1.
851.
I am for respondent number 1.
In the IA.
In the IA.
IA is filed by the respondent 7. Order dated 35.
Malo.
Objections, if any, may be filed in the meantime.
Malo.
Respondents are prompted. 26th of June.
June.
I am deeply off.
For applicant, order number 11. As for 1, 2, 3, 4.
I am deeply off.
This is a land acquisition matter.
Yes.
Compensation has not been paid initially. They treated our area as forest area. Thereafter, an affidavit was filed that our area has been reserved.
Readings complete.
readings are complete. One affidavit is there.
Regarding, my lord, the notification, my lord, initially, my lord, 299 acres lands were, my lord, declared as a de-reserve forest in 1965. Now, subsequently, 3 notification was issued on 5th June, my lord.
Have the parties completed their
Yes,
reading?
no, my lord, I have to file my affidavit, bring it on record about the 3 notification, which may be granted.
Bring it.
Lordship, in this case, Lordship, the area total under 5 kilometer was under construction bypass road, Lordship. And out of 5 kilometer, my lord, 1.5 kilometer is, Lordship, hindrance created by the petitioners, Lordship. So, since last 7 months, Lordship, our work has been stopped, my lord. So, we may be permitted at least to go with the construction road because this is a national importance, my lord. Last 7 months, work has been stopped, my lord.
You file your petition properly.
Yes. And moreover, they have taken over the position of the land without paying the
And
compensation.
in this regard, Lordship, Ministry of Environment and Forest also.
Interim order.
Lordship.
There is no interim order.
There is no interim, my lord. Lordship, but people are keeping the Lordship.
Then you file proper application. If there is no interim order, why do you want the direction from the court? On a petition filed by the petitioner. Heard done it. Then the council, Karbi Anglo. You are for Karbi Anglo.
My lord, we have already filed a affidavit, my lord, on behalf of the Kala. My lord, we want to file an additional affidavit and affidavit on behalf of the Forest Department.
625.
Additional affidavit on behalf of respondent number 9, my lord, and the affidavit on behalf of respondent number 9, and the affidavit on behalf of respondent number 13.
The keyboard report.
Lord, I am for 1, 3, 10, Lord.
1,
3, and 10, my lord.
1, 3, and 10.
Yes, ma'am.
Now, who is constructing it?
Lordship, NHIDCL is constructing the road, my lord.
Respondent number 10.
Respondent 3.
Yes.
So you construct, don't take you, there's no stay order.
That may be recorded, Lord. In the order, my lord.
Why should
Lord,
you record it?
Lord, we'll file application.
It will be listed under some of.
Right, please, Your Lordship. This is that matter. Last week, Your Lordship had heard the bank had held an auction around 10 years ago, and the payment was made, but the possession of the property was not handed over.
Yes.
May it please Your Lordship. Your Lordship, the engaged counsel, due to some medical emergency, had to leave immediately. Your Lordship,
Engaged counsel.
Miss S. Das. Your Lordship, she was waiting since morning, but due to some urgency, she had to leave immediately.
Now, what is to be done?
Your Lordship, please fix the matter on Tuesday at earliest.
Tuesday.
Tuesday.
Lordship, I have checked the district court status as Ms. S. Das had submitted on the last date that the title suit which was dismissed for default has been restored. But after restoration, there is no injunction order.
Tuesday, all right. Before Tuesday, as it is submitted by, on behalf of the council for bank.
Bank. Respondent 1 and 2.
Respondent 1 and council. Is it responsible? Then be available. 18.
Deeply obliged. Highly obliged, Your Lordship.
On last date, Lordship, directed to take instruction regarding further.
Instruction received, Lordship. The freezing account of the petitioner is no more required in connection of the PS case number 325.
No more?
Required, Lordship.
Give us
Yes.
further
on instruction has to be obtained as permitted by the court. On the instructions obtained as permitted by the court, and it has moreover that the Deputy Commissioner of Police Crime Party has informed that the account of the writ petitioner hearing number, what is it, savings or current?
Saving account.
Savings account. Hearing number 303340633796 of the State Bank of India Notary branch, which was frozen during investigation of Carmody PS case number 325/2023 under section 120-B/406/420 is no longer required in connection with this case. So, but why this communication is not sent to the bank? In view of such submissions, the bank, namely the SBI Notary branch. No, but who's for SBI?
SBI वाला to take a service is complete. They have not appeared. To take an issue.
In terms of the earlier order, the
I think that's a formal body.
notice was directed to be served on SBI by registered postage. Office report dated 26/2024.
Where the looks of Lavadima order.
Sorry, office report dated 005/2024 reflects that the postal consignment number was tracked in the webpage of the postal department, and the report available there shows that the item has been delivered at receipt. So, accordingly, it has to be it is held at the service of respondent board. However, none represent the respondent after board named branch manager SBI number. In view of the submissions made by the council and on perusal of the instructions placed before the court, the petition is disposed of in the direction of the respondent of the board to verify of the office of the city crime party in respect of the information that has been placed before the court that the savings bank account hearing number 22 in the branch so is no longer required in connection with January PSK number 22, and the account is therefore no longer required to be frozen. If that be correct, if that information, upon due verification of that information, the SBI authority will forthwith decrease the savings account number 22 available in the bank, extending in the name of the writ petition. This entire action be carried out within a period of 2 weeks, 15 days from the date of receipt of a certified copy of the
What's it called? Direct to the
respondent number 40. Official answer, they have fixed my account.
Huh?
They have fixed my account. Official answer, Sarmai police station.
The respondents number 2 and 3 are also directed to communicate to the respondent number 4 that the accounts, savings account for the petitioner is no longer required for the purposes of investigation of this state case and should therefore be defreezed. All these directives be carried out in a
Highly obliged. I have filed the certified copy of contract agreement.
Okay.
And the flag one is having the condition 70.
What do you say?
May I please, Lordship? Lordship, we have received Parawai's comment. We will file affidavit. 3 weeks may be granted to file affidavit.
You are representing whom?
For all the respondents on behalf of RTB.
Your Lordship, I want to submit some document here. That in reply to our letter for appointment of arbitrator, the respondent has written us to accept and condition thereby condition 12.5 can be waived off. And in our reply, we have rejected it. And furthermore, I have Supreme Court order that once the arbitrator, once the second party moves the Supreme this order,
Where is the arbitration clause?
That is condition 70.
70.
70, yes. That is highlighted. That is page, the page is flagged. And there is no dispute, they have replied us.
This is about some amendment in the arbitration clause.
That's why I'm
Clause 7.
That's why I'm submitting some document, Your Lordship. They wanted us to sign it, sign and by condition 12.5 can be waived off so they can appoint arbitrator from their panel. In reply, we have rejected it. After that, we have submitted Supreme Court judgment that once we move the High Court for appointment of arbitrator, the opposite party cannot appoint the arbitrator. And all the reply are yes, Your Lord.
The arbitration clause, I don't know, it talks about some amendment in the arbitration clause. So where is the original arbitration clause? This one is you're highlighting.
Yeah, condition 70.
70, but this is with regard to the amendment carried out in the contract work. So,
Your Lordship, they have said it in their reply. In their reply, they said that there is some amendment in the ENC policy. And according to that, they wanted us to sign the availability of condition 12.5 of the arbitration.
12.5.
12.5.
No, 12.5 is the mandate of the statute.
They wanted us to sign it so that departmental arbitrator can be appointed. So we have rejected, we have not accepted it, and we have replied it.
In your agreement, I am unable to locate the arbitration clause.
Arbitration clause, Your Lordship, in the petition, only condition 70 is referred. So in petition, in original petition, you will see page number 16 and 17, where that is elaborated.
So why that is not available? You have enclosed the agreement.
That's why I told sir, the only condition 70 is there, but they don't do all the homework to input all the detail of the condition. And that I got from the contract manual. In page 16 and 17, last page of the petition. In the original petition.
Let them bring that contract report. We'll see. Contract agreement. You file it.
This is the contract agreement your notice complete.
No, it's not very clear from here.
It is all Xerox.
So we'll ask them to get it. When can you get the contract agreement?
3 weeks may be granted. 3 weeks.
It will
Why
be too
3
much.
weeks is like required? Where is it coming from? Tezpur.
It will come from Tenga, your lord.
Tenga.
Arunachal
Pradesh.
Arunachal.
So Tenga will not take 3 weeks time.
And even
we have it on 26th of June.
26th June. No? Okay.
Heard, Mr. You are Mr. Sanjay Sharma.
Yes.
Petitioner in person and MS representing CGC. The CGC is directed to place the contract agreement before the court. Since the dispute raised by the present petitioner regarding appointment of arbitrator, in view of the disputes, I claim to have a reason between the petitioner and the respondent in respect of works allotted to the petitioner by way of contract agreement number CWE/TEZ/859/02/2018. Yes. You are appearing? Yes. Get the contract agreement first, the contract arbitration clause. We are fixing it on 26. List according.
May I please, Your Lordship? Lordship, as per office note dated 12/6/24, the petitioners have failed to provide the amended memo for parties.
On behalf of Mr. K. Kumar, my senior lordship. Here, my lord, on the last order dated 3/6/2024, this honorable court directed to submit one
Amended cost.
cost item. However, my lord, we have skipped it. My lord, please give 3 days time to file the amended cost item.
Amended post title is permitted by the court, filed in 1 week. The petitioner, anyone else?
Yes. I am for respondent number 6.
I am for respondent 5 and newly pleaded party 8 to 12.
Respondent 5 and 8 to 12.
Sanjay Kumar sir.
Respondent
6.
Borwa for
2, 3, 4, 7.
Adorika for
1.
Lordship, a similar matter has been fixed on 22nd of August.
Let him file. Right? Let him file the amended post title. You
Obliged.
you
Obliged.
prayer on the return of
Okay.
Obliged.
Lordship, may I kindly produce the last order. This is a case where the petitioner before Your Lordships is seeking the benefit of the Prime Minister Awas Yojana, Your Lordships. He is a beneficiary considering the fact that he was a person with disability. His name was not recommended by the state government especially the PNRD department in the list which was formulated. So eventually when we filed the matter before this court, they filed an affidavit on, Your Lordships will find that on 5th of March, they have filed an affidavit in opposition saying that in the list, my name was at serial number 41. And out of that, 39 beneficiaries had already been given the benefit of the scheme. So as per the affidavit of that particular date, my name was at serial number 2. Thereafter, on the last occasion, although it has not been reflected in the order, but there was a statement which was made that, in fact, my name is now at serial number 1. And therefore, Mr. D. Nath had appeared on the last occasion and had made a submission that during the interim election period, the model code of conduct will not hamper this particular scheme, and that his name would perhaps be recommended. That the Lordships will find on 28/3/2024, the order dated. Your Lordships have seen the order. Accordingly, Mr. Nath submits that the matter will be adjourned, and on the next date fixed, he will obtain the up-to-date instructions as regard the allotment of the house in favor of the petitioner. The first paragraph also, Your Lordships, Mr. D. Nath, learned senior government advocate, submits that the list in question which will not lapse on 31/3/2024, and the petitioner can be accommodated with the house under PMAYG when the next allotment is made. And then the order also stated that pendency of this petition shall not be a bar to allot the house as stated by Mr. D. Nath. Subsequently, it has been listed today before Your Lordships, and I'm not sure what are the latest.
Lord, I've received a set of instructions. Page 3 is very relevant, my lord.
Tell us.
The instructions is that, my lord, what the PNRD department does, it forwards the list of all the eligible beneficiaries to a software that has been created by the Ministry of Rural Development Department, Government of India. So his name, the petitioner's name right now is at serial number 1. What the Ministry of Rural Development Department did is that it freezed its website, this Awas Plus website, and it stated that this entire software will be freezed till the end of the model code of conduct. So right now that code of conduct has been uplifted. So what is to be done subsequently from here on, my lord? It is the government of India, my lord, that is answerable.
Yes, government of India.
As to when they will when they'll make that particular software.
Unfortunately, they were not a party to this instant petition.
They need to be.
This was a
Right.
development. I must just point it out to your Lordships.
Get it.
Yes. Lordships, considering the fact that Modi 3.0 had the first decision is about the Awas Yojana, I guess this should cover it. That was the first decision taken by the new cabinet, that the PMAY scheme will be extended to 3 crore further beneficiaries. Your Lordships.
The ministry ought to be implemented, my lord. The Ministry of Rural Development.
The mistake which they have done, your Lordships.
First, where will it be? If you can find out that the software is operational, perhaps
Save time, save a lot of time.
The mistake which the government of Assam has done is that they have not forwarded my name under the person with disability category. That is why I have been left behind. Anyways, if my learned friend can get instructions and so far as the website is concerned.
we can implement. If one implement, we
Lordships, like if she can get instructions, I'll serve an extra copy on her, and as your Lordships deems fit. Perhaps it might be best to implement them as a party respondent, and then I'll take fresh service on my learned friend.
Right, third learning council for the party. Did you file an application for implement?
Lordships, your Lordships will just direct implement. I would be much obliged to your Lordships. Poor illiterate man, your Lordships.
It submits on instructions that the department has forwarded also names to the government of India.
Page 3, madam.
And the government of India has
in the
website where, as per information available, the name of the writ petitioner appears as serial number 1. So, however, in view of the recent election and the model code of conduct that was implemented, the Ministry of Rural Development Department of India has frozen the said website.
Frozen.
At present, he does not have instructions as to what further steps the ministry would like to take to be list put up in the website. So, considering the fact that instructions from the Ministry of Rural Development, what is the ministry exactly?
Madam, the ministry is at page number 2. It is Ministry of Panchayat and Rural Development.
No, but it's not the ministry is to be completed, it's the department. What is the department?
That's the Rural Development Department.
The Rural Development Department.
Government of India.
Government of India.
Sam.
This is Ministry of Rural Development Department, Ministry of.
Ministry of Rural Development Department represented by the Secretary of the Department. Would be required to furnish the necessary in view of the submission made by the Council for the Department of Madhya in order to, but the State Department is not considering the fact that this information is required from the Ministry of Rural Development. This court deems it proper to array the State Department of Rural Development, Ministry of Rural Development. What is that exact? Give us the name exact. What is that name?
Ministry of Rural Development Department.
Ministry of Rural Development Department is the party respondent number. Party respondent number
7, Your Lordship.
7. Ministry of Rural Development Department represented by the Secretary. The Learned Council, so since MS has forwarded the CPC available in court, she accepts notice on behalf of the newly created responsible 7. There is a way, however, extra copies are furnished, be furnished the Learned
I'm punishing right now.
Council within a period of 1 week. The respondent will obtain the instructions and place it before the court. And to be listed in the 3rd week of July. On a date to be fixed by the date.
Give your Lordship.
Order, copy of order.
Copy of this order be marked in the office of the CPC for further communication, for onward communication to the concerned department. Petitioner will file amended post item in the raised within a period of 1 week from today. Yes.
May I please, Your Lord? In this case, Your Lordship, on 13/06/2019, petitioner was raped by one Sunil Rava, and accordingly, she was applied for. Her father was applied for compensation. That application was lying pending. Thereafter, petitioner herself filed an application through State Legal Service Authority.
Someone has filed an affidavit in opposition.
Yes,
I have, Your Lordships, saying that, in fact, the DLSA has granted some compensation to her. Interim compensation was to the tune of 50,000, and thereafter an award of 3 lakhs rupees has been made in her favor. But due to paucity of funds, that money has not been, we have not been able to release the money to her, Your Lordships. The DLSA order is at Annexure B, page 39.
Relax.
Yes, Lord.
So, anything?
Our claim is 5 lakh, Your Lordship, as per notification 01/02/2009.
Challenge this order.
Yes, Lordship, because we have it come in light after filing.
Challenge this order.
Lordship. In this petition, we have not challenged, but we
In
can.
this writ petition, you have not challenged, but you have to challenge this order.
Yes, but amount is not disbursed. That's the reason. Your Lordship.
Amount is not disbursed. Your petition was praying for directing the authorities to pay an amount.
Absolutely. Lordship, maybe remand back for look into the matter as per the notification.
No. The writ petition is filed by the petitioner praying for a victim compensation of rupees 5 lakh. Yes, it is submitted that petitioner
may I submit one thing, Your Lordship? Lordship, as per the provision, the appeal may be made within 90 days, but it came no less on 15/5/2024 after filing this writ petition. So Lordship maybe make an observation of the order.
What was the incident?
Incident on 13/6/2019.
Where does one find it?
Lordship.
Paragraph 2, page 5, Your Lordships.
Page 5?
Paragraph 2.
The victim is before the court.
Yes, Lord.
Petitioner was physically violated by the person named as an accused in the FIR. On 13/6/2019. So the FIR was received and registered on 19/6/2019 and was registered as Kokrajhar PS case number 288/2019 under section 376.
Matter went to trial, Your Lordship. Sessions case number 134 of 2019.
Went to trial and
Sessions case number 134 of 2019. But the trial abated.
pending matter was pending before the trial court as sections case number 134 of 2019. So, however, this trial of the accused, the case abated as the accused died during the pendency of the trial on 3/3/2020. The petitioner was granted interim compensation of 50,000 by the district legal service. However, the compensation as required is the provision of the victim compensation scheme framed under the government of Assam has not been received. Being aggrieved, she has ventilated her advances before the district, before the Assam State Legal Services Authority as well as the district legal services authority. However, the same was not redressed and therefore she could not go. So, during the pendency of the writ petition, the petitioner was granted compensation of 3 lakh district legal services by order dated
24/7/2023.
3rd of April.
Lordships, it could be
24.
24/7/2023.
24/7/2023.
Lordships. Lordships, you may just
You filed this writ petition in 24.
Yes, Lordship. After filing this writ petition, it comes to knowledge that they have already awarded the amount, but due to non-ability of fund, they are not disbursing the amount.
In any case, Your Lordship, the schedule as per the act is the minimum compensation which can be granted is
This
3 lakh.
order having
Lordships.
been passed.
Yes.
Is a copy not communicated to the petitioner?
Lordships, I do not know. They have not, in their, these petitions are filed frivolously. They do not come with the entire facts before this
You bring
court.
it on record. You produce the record and tell her. In 23,
yes,
this order has been passed. You come in 24.
Lordship, because petitioner appeared before the respondent number 3, but they are not informed that's why we are
That's
filing
what
this.
we want to find out. If they have not informed, why have they not informed?
Yes, Lordship.
Lordship, that is normally not the case. Of course, the DLSA will be able to answer that better.
DLSA government.
Government normally appears, Your Lordships.
Please get instructions from the DLSA Kokrajhar as to whether the order. Do you have a copy of the petition?
Yes, sir.
Kindly come to page 39
More affidavit
or annexure B of the affidavit.
More affidavit, continuation of pagination. More affidavit को बता दो. Wait.
Character B of the affidavit.
Yes, Your Lord.
There is a reflection that the amount of 3 lakhs have been ordered to be paid to the victim by an ELS way back in 24/7/20. Victim is the petitioner, and he submits that he is known order. Find out from your record whether this order was communicated or not. Get all information.
Not because their limitation period also.
We'll see about that, but you tell us whether you have received it or not. Let the government advocate produce the relevant records to the court containing the order dated 24/07/2023 passed by the District Legal Services Authority of Gujarat, whereby an amount of rupees 3 lakhs has been paid as final compensation to the writ petitioner. Stop. These records are called to verify. Records are directed to be called for. In view of the submissions made by the learned counsel for the petitioner that the victim / the writ petitioner was not aware of this order, which was passed way back in 24/07/2023. The learned government advocate will apprise the court if copy thereof was served on the victim / the writ petitioner and the manner which it was done. Let the matter be listed again on 26th of June.
Lordships, not 25th or 27th, Your Lordship.
27th of June.
27th.
And MS RS Chaudhary appears for respondent number.
And for this one, 2 Your Lordships.
Respondent. You have copies?
Yes, that's good.
Copy of this order be marked to the office of Purva for onward communication. Please get the record, get a seat.
Obligation. And Lordship, in item number 51, the name of the respondent number 7 should be Ministry of Panchayat and Rural Development, Government of India.
Your
Panchayat and
Rural
Rural
Development.
Development, Government of India.
Give me to please go to one. Obliged, Lordships.
Yes.
May I please, Lordship? Lordship, here updated report was called for, status report, that is there in the report.
What do you say? Supply of cookie.
That is this. And he is regularly appearing. That is there. After interim.
There are 6 and 7.
But the evidence has not even started.
No.
How long? Likely.
After copy, it will fix.
Let us
For charge, framing charge, thereafter
framing charge,
evidence.
You are on interim.
Yes, yes.
But
Yes, no problem.
We'll see your hard learned counsel. In terms of the order passed earlier, the status order is placed for court from additional CA order, where it is stated that the case is presently at the stage of supply of copy at the so further mentioned that the petitioner accused, what is his name?
Lalbor Ali.
Lalbor Ali.
attending court every day, for the same. However, however, that charges have not yet been framed. Therefore, at this stage, court of appeal has matter called up again after 4 weeks. Interim order is paid for, but we until further order. Matter be listed after 4 weeks.
Yes.